Okay, so thanks everyone for coming. It looks like we have around 30 participants for the second such topic meeting. Very exciting. I'm recording this so that folks who don't get to come can also see, and I'm going to upload it to YouTube. The purpose of today's meeting, in contrast to the last meeting, is to start solidifying what our ballot looks like. So one thing that I think everyone should keep in mind is that at this process, we're not selecting a resolution. We're looking for a slate of resolutions that satisfy multiple constituencies. Obviously, folks are going to disagree on different components of what makes up a good resolution. And I think that there's space on the ballot for all those different constituencies, and we can kind of let democracy decide what the preferred approach is. Democracy is a flawed system, but it's the one that we have. So yeah, the first thing I want to cover is just kind of what I currently envision the slate will look like. It's 1.0, so obviously things could change. We could push things off the ballot. We could multiply the number of options or wording options within the individual sort of like sections that are here. But right now, we could envision having a SCOTUS resolution, a visas resolution, a refugee asylum resolution, an enforcement of immigration law resolution, and then a large resolution that would encompass multiple sections, including visa and refugee in particular. That would sort of be a umbrella resolution, more similar to the high school topic. So the options that we have going forward obviously are eliminating some of these areas if we decide that there's no viable topic underneath that area, or if we decide that some areas are sort of the consensus best areas and we should have multiple wordings under those individual areas, or if we should have some different area that's not been discussed so far. So areas that have been sort of brought up that aren't on this list, I wanted to give time for folks to kind of make their case and discuss those. So one such one that I know of is Scott Thompson has proposed, and others have proposed as well, adding an area to the list that would increase immigration restrictions or would decrease the amount of immigration, kind of the opposite of the direction of the other ones. So Scott, did you want to talk about that for a little bit?
Yeah, I thought that it would appeal to a constituency that wanted to do foreign policy topics, because a lot of the literature addressing immigration talks about the causes of immigration. So if you could get to those, that would be all right. At the same time, it would allow for the whole menu of sort of reactionary policies, but it also would allow for some progressive policies where immigration is, patently unfair. For example, people that can buy green cards, some of these types of programs. So you don't have to be a reactionary to be an affirmative that restricts or decreases immigration in some way. That would allow the negative to have, I think, a much wider range of arguments than exists with most of the other topics with the other direction. I think that the first negative options, the negative options are somewhat limited with the increased immigration topics. That's my.
Yeah, I read your proposal, and I was a little confused, so I did want to ask a question. So you're proposing
Sure.
that apps that would focus on reducing the demand for immigration, so things like providing international aid to countries going through economic crises would be topical under your proposal, because that reduces sort of the flight.
Sure.
The desire to immigrate to the U.S., rather than apps that say we won't allow people in.
Well, it would allow for those. If you had a topic that said adopt policies to decrease immigration, it would allow for foreign policy topics, and it would also allow for the sort of
think Scott froze.
Oh no.
So while Scott gets that sorted out, what he's proposing is a resolution that would look something like the United States federal government should adopt a policy to decrease immigration to the United States. So I'll write that in the chat real quick so that we can see it.
I
Is there any reason why we have to say adopt a policy to, and why we couldn't just say United States federal government should substantially reduce immigration to the United States?
The idea being that the action of, like, because reducing immigration to the United States is a result of a policy and not a policy in and of itself.
So we could
Yeah,
basically
right.
say that United States federal government passes some kind of a policy that makes like immigration less desirable, and that becomes topical. Is my
Yes.
kind of
I
That's also the-
am,
That's also
fine.
topicality.
yeah, I am a little, highly skeptical of the topicality debates on that resolution.
Yeah,
But
that sounds like it
the
demands.
topic that we just debated, really, solvency and topicality were completely collapsed.
I definitely agree with you, and I think we should definitely avoid doing that in the future and should never try to do that again.
Yeah, it feels like that's been the last couple of resolutions.
Yeah, and I think this is really a problem we should avoid, not one we should embrace. And I think in this one in
Agreed.
particular, I'm thinking
That
of this,
would
and not
only
even
be-
insofar as mixing burdens. I think additionally, my other problem with it is sort of like I
See,
can
but
make anything
it's
topical.
it's not a requirement of the solvency. If I ran a case that said, let's do a Marshall Plan for Central America, I wouldn't have to have anything about immigration in the affirmative at all. You could run a topicality argument saying that would not decrease immigration, and then I would have to respond. It doesn't
real quick,
necessarily have to collapse the solvency topicality. You know, that they're not essentially, they don't have to be the same argument.
real quick. So everyone obviously like wants to participate and talk. Does everyone know how to use the raise hand feature?
Oh, no, I've not been
No.
doing that. I'm sorry.
I have no idea
so-
how to use it either.
If you click manage participants,
It probably wouldn't say manage participants because you're not hosting it. For me, it just says participants. It's at
Oh, I
the
found
bottom
participants.
next to chat and share screen.
Everyone should have a participants down at the bottom of theirs, and it's going to depend on how large your window is, if you see it or not. You may have to hit the more button to find it.
Yeah, I
Um,
just kind of I always kind of keep it open on the side in general when I'm
Mhm.
using.
So I'll just start going with people that raised their hand. So Riley,
Hi. For those of y'all who don't know me, by the way, I'm Riley. My pronouns are they, them. I'm probably doing NFLD next year. Aside from the FXT question, I think this topic is like the biggest topic ever written ever. If it allows apps that like give aid to a country and then says that reduces the desirability of immigration, because you can stop arms sales to a country and say that stops conflict, which stops refugees. You can give any kind of aid to any subset of countries, which means it encompasses development aid, military aid, economic aid. You can change trade inflows and argue that that strengthens the economy of any country, which means that this is also a trade topic, which allows any trade policy. Basically, any foreign policy topic ever written, you can read any argument on the topic, and it's a topical plan, and just read one argument. You just read one card at the bottom of the app that says instability causes refugee outflow, and then you're topical.
makes sense. Dustin,
Yeah. So I guess I'm not going to talk about like the thoughts on like limits per se, because I guess Riley's correct and like some other people handle that. But maybe if we were to think about rewriting resolution along the making the app decrease immigration, which might be a more productive way to go with this conversation. We might want to focus on like a particular mechanism. So maybe like decrease visas, or decrease admittance, increase restrictions to admittance, or something along those lines. Because if it becomes like a Central America topic, I mean, I don't know, like will be kind of hard to win that something's not topical.
okay. Then we have Noel.
I guess I'm in agreement with both Riley and Dustin, just generally that I think even like nuking a country would be topical under that resolution because nobody can immigrate if they're dead. And that might be something, I mean, that's what I would tell my kid to do in an out round, but I'm a bad person. You can ask my debaters, they'll tell you. But otherwise, I guess in reference to the a policy that portion of this conversation, Deb, I don't like it, and I haven't been able to have a good alternative. I guess perhaps can we do the United States federal government should, with an act of Congress, substantially increase, because that seems to sort of like not mandate that weird policy wording that I just don't think has served us very well, and mandates that policy action allows us your agent counter plans of your SCOTUSes and your EXOs if you wanted to do that sort of thing, which we can't anymore as easily. And maybe that would be better.
Scott? Scott, are you there?
He's muted. I think he's muted.
Scott, you're muted.
If it had immigration to the United States, you would rely on the literature that somebody has to say that this would decrease. You couldn't just be speculative. I think that would be a pretty clear standard, but if literature is not a check, then that's fine.
Nadia? Nadia?
Nadia, you're muted.
Sorry. I think I agree with a lot of what's been said by like Noel and Dustin about the negative action topic. I think that it creates far too much AF flexibility. I think even within the literature base that does exist, there's just far too many ways for the AF to pick a singular country or even a singular region of a singular country, and then just allow themselves to be like, oh, well, we just won't grant, visas to people between these latitude lines, even in some capacity. And that would technically meet with no negative topic literature to regard that. I think that like the debate about whether or not immigration is good or bad is something that's not going to be hashed out very well in an LD round to begin with anyways, in a negative action topic. So I think that it's putting too much burden, I think, on the negative to be possible to win in the format if we have a negative action. There's just way too much potentiality for the AF to do whatever they want within the literature bases that do already exist to kind of just overwhelm any negative prep squad, no matter how big or how many people you have cutting cards.
Tess?
I don't know if this is really important, but I feel hesitant about the idea of the phrasing adopt. I'm not sure if that makes sense, but like I think implement a policy probably would resolve some of the like actor claims that people are doing, because I don't know, adopting has some leniency, but they're synonyms, so kind of minute and not really about what the topic would look like.
Shirna?
Yeah, so I actually kind of like this idea, honestly, more so than the other ones. I just had one thing was, if it's pass a policy, couldn't that resolve the issue of that it has to at least go through Congress? That way we don't have to add that wording into the resolution, number one. And then my second question was, Scott, you're saying that it would allow us the international aspect, which is what I'm really interested in. So I was wondering what you meant more by that, of how it would be an international if we do the reduction.
Oh, it's to decrease immigration. A policy to decrease immigration would be the volume. Miswrote it, but that was my intention.
Okay, I guess I don't understand how decreasing
a Marshall Plan for Central America would decrease immigration to the United States.
Right. No, I'm following that. What I mean is, I guess I don't understand where the differentiation between that it gets it to be more international than domestic versus an increased immigration topic. I guess that's where maybe it could just also be that I have a massive sinus headache tonight.
Right. I'm not sure. The international aspect is somewhat limited with the increased ones. I guess you could allow immigration from Suriname. Yeah, then that's international, but I don't think there's tons of affirmatives out there. I mean, I guess you could say, U visas from El Salvador because they're for victims of crime. And if that's the case, then my concern about this not allowing for international type cases is alleviated.
Okay. That's right. I was just curious. My brain wasn't wrapping around it. That makes a lot more sense. So cool. Thank you.
Let's circle around to Darren.
Yeah, I think Scott's concerns about the international aspect can be weaved into some of the other topic area directions that actually are an increase in immigration. I will wave this flag again that I don't think we are being holding fidelity to the topic paper if we offer a resolution that's the opposite direction of the topic paper. And so I'm always a fan of sticking to that direction as closely as we can. And so I think if we want to talk about these international aspects, and Shanna brought up a good point, we can weave those into some of the other areas that would actually increase immigration. And I think Nadia is spot on about the negative action aspect of a topic that goes in this direction in the limited amount of time in debates in LD, I think creates more problems than would actually be resolved by a resolution that goes in that direction. So that would be my preference, is that we not even offer a topic or a resolution that goes in the direction opposite of the topic paper.
Oh, they were area papers. I didn't raise my hand.
Oh, it's okay. I see Rebecca, then Jared.
Yeah, I mean, I agree with a lot of what's been said about the negative, about doing a negative action over a positive action for immigration. I think that especially as a debater, that doing a negative action really harms the negative in that regard, because we can't really prepare, because it gives apps more leniency to make a new app immediately or for outbound specifically. So, but I mean, that's a lot of my concerns with it, but what else has been said, I firmly agree with, though.
Okay, then we got Jared.
Okay, so, man, that's a lot of stuff now because a lot of people are speaking. But I think that, speaking on this issue that Scott brought up, I wouldn't be opposed to including a resolution on the ballot that talked about reducing immigration, because I think if we look at topic resolution ballots from the past, I remember the Latin America paper literally had nothing at all to do with the military whatsoever. When we wrote it, there was nothing in there about Southcom or anything. It was a trade paper, but we ended up with a military topic. So that's been true. There was not bioprospecting in that bioethics paper. So there's been a lot of examples where we have not had a whole lot of fidelity to the topic paper. So I wouldn't necessarily see that as a reason not to include sort of an opposite direction resolution on our ballot, on our slate of resolutions. My larger concern, though, is that a resolution to increase restrictions or whatever to reduce immigration that both allows Build the Wall app and Marshall Plan for Latin America. While I agree, Scott, that you do need lit, right, and that the lit would check somewhat, I think that it still allows far too much half ground for the negatives to ever really catch up. I don't think that every single app we can imagine would be supported by literature, but I think that there's a lot of them out there and then they start to snowball. Once somebody figures one out, then you find a different article that kind of does a similar thing, and you start ending up with, millions and millions of tiny apps. And that becomes really, really rough for the negative on a topic area that we already know is going to be rough for the negative.
Riley, then Zach.
Yeah, I agree that it's impossible to kind of limit those apps out of the topic. I think just for example, there was a lot of literature that was written when the Syrian civil war started, which says like the best way to stop refugee inflows from Syria is to like stop the US's support for like proxy elements in Syria and stop the US's support for the Kurds. And I think that probably for every conflict, because the US is involved in every conflict, for every conflict that causes refugees, there will be an author who says the best way to stop the refugees is to stop the conflict, which means that you'll find lit, which says that you're topical under this model of the resolution, which allows things like a Marshall Plan for Latin America to be topical. I think that a better wording of the resolution is the one that I proposed in the chat above, which says that the US should increase its regulations on legal immigration. I think that this might avoid the negative action problem. I'm not sure I understand why the topic is necessarily negative, but I think that this does avoid the negative action problem because it requires the app to defend an increase in regulations. It also avoids some of the problems with like broad resolutions being too big, just because the majority of the literature advocates for increases in immigration, which means that there's less literature which advocates in this direction. So I think that it allows us to get a broad resolution which talks about a number of areas of immigration without making without creating too many topical Fs.
Zach?
Yeah, so one thing I will say about the negative direction topics is it might be a good way for us to be able to avoid any kind of election concerns that we have. Because like if Biden gets elected, that will be like increases in immigration. Whereas if Trump remains in office, like there's probably going to be like a uniqueness or disad question. But I think that like overall uniqueness concerns would be a lot better in a world of negative immigration as opposed to increased immigration. That's my thought. It could go either way. I mean, Trump puts up travel bans and restrictions all the time, which could, like I said, throw off a little bit of uniqueness. But at the same time, I think it could be like overall better than just saying like we're going to increase the amount of people that we allow or decrease regulations, especially if Biden gets in the White House.
Yeah, I'm gonna clear the board of folks, and I think we can move on. One note though is that I think at this point Trump is trying to ban all immigration to the United States. So on some level, it's like any immigration topic we have is going to be impacted in some way by the actions of Trump and or Biden. Dustin, Booker, Ravi?
Oh, sorry. That pretty much covered like the election privilege.
Yeah. So I do think I'm not like opposed to putting it on the ballot, but I do think, kind of to echo some other comments, is we should stop like thinking about topicality as in order to do X thing or with the aim of doing X thing, but rather think about what the kind of legal terminology is around particular mechanisms, because I think that there's lots of concerns that I agree with here about the limits of this sort of topic. And it doesn't seem that, there's a way to limit that without getting into the legal wordings and specific mechanisms. So if you want me to vote for this topic, I think that kind of rewrite would like help a lot. I mean, yeah.
Booker?
Yeah, second to everything Dustin said, first of all. And then also, I guess, I'm sure this is part of our intention when we talk about that specific kind of topic of increasing regulations on illegal immigration. My question is, how do we feel about that being almost I feel running a risk of almost bi-directional, and then because I think it depends on who. It's just a regulation on illegal immigration. The question is on which person's involved in illegal immigration. Can it be regulations on government actors involved in illegal immigration? And of course, there's always the fact that I think most people don't enjoy Regulation T. Just throwing that out there. That's neither here nor there, though. There's going to be a tea debate that we all hate somewhere.
We'll end with Riley, then move on.
Oh, sorry, my hand was not supposed to be raised.
Oh, I apologize. We'll just move on. So lots of good points brought up. The concerns that I personally have are, one, the fidelity to the topic paper. Folks have brought up examples from the past when the topic paper sort of like said X and then Y was the resolution, that I didn't agree with that. And one of the reasons why, for instance, last year I chose not to make a whole set of topic paper or topics that just focused on the adaptation component is that I didn't feel like it was fair to the topic writers who advocated for more sort of like mainstream renewable energy topics. So to me, it does matter that it doesn't jive with the topic paper, though obviously not a complete game ender. And then, yeah, I definitely share some of the wording concerns, but I think there's definitely some potential there. So to move on to some of the proposed or the areas that have been discussed, I guess first, because I figured it would take the longest, wanted to kind of go over SCOTUS and some of the issues that have been involved. So just to maybe catch anyone up who hasn't been following the LD community discussion page, a topic paper or sort of supplementary paper was written concerning SCOTUS, basically a resolution that would focus on the Supreme Court overturning a series of options relevant to immigration policy, being one of the options on the topic. The concerns that have been brought up are A, that there's no good way to resolve test case fiat, or that there isn't a test case that's currently in the sort of like district or appellate courts that the Supreme Court could rule on. Basically, like, you need to have a case in order to have a writ of certiorari. Then that there's some overpowered counterplans that the NEG gets, such as the Congress counterplan, counterplan, I'm sorry. And then also that there may not be advantages that would allow big stick affirmatives. By big stick, I just mean like we solve a huge sort of like structural thing that like results in like nuke war extinction, etc. There's also some smaller debates on the overturn wording, the holding wording, and the extent to which those sort of determine the topicality of potential affirmatives that could overturn a decision sort of like on the grounds that wasn't relevant to the original decision itself, and allow the YAF to claim sort of like really unfair advantages. So Justin wrote that, so I wanted to give him a chance to sort of talk about those issues, and then we'll obviously open it up for the comments and questions and concerns from everyone else.
Yeah, so there's a number of reasons why it's like important, in my opinion, to have a courts topic. I'm going to hold off on that, though. I think particularly Sarah has a spiel about that. We've been talking about it, and I know on the test case fiat issue, I'm not sure I want to met that out right now, because with this has like been ongoing for like 2 days. But I think that it's fair to say that test case fiat is not as persuasive of an argument as a lot of people seem to think, because the Supreme Court all the time just like is like basically send signals that they want to overturn particular previous holdings, and there's test cases ready to go. I know there's some ground arguments for why the AF needs a test case, but there's substantial debate about that, and I think if we choose SCOTUS, it becomes much less of a persuasive argument in that world. I think the best argument is this ground argument, but I'm not sure what, like, and that it allows the AF to fiat solvency, but I'm not sure that's true, because every case that I've chosen on this list has debates about the importance of the case. So there will be people in the law literature that will write like, we should overturn it, it'll do all these things, and people will respond with, this wasn't as important of a case, here are some alt things going on. I think that, and so I'll talk a little bit about the counterplan stuff and the advantage stuff now. So the counterplans I've built in a consideration of the different possible counterplans into the cases that have been chosen. So there are, for each of the advantages, there's SCOTUS-specific advantages that can't necessarily be solved by an amendment or by something else because they're about the court's power in relationship to the executive, or which is like the plenary power doctrine, which is really bad. Or they're about the ability of the courts to intervene in administrative decisions, right? So the doctrine of visa non-reviewability. And these are advantages that can't really be resolved by most other process counterplans because they really rely on the Supreme Court signaling as a central kind of premise of the advantage. I do think that the one I would worry about, in my opinion, is the constitutional amendment counterplan. But there's really good evidence in the last year or so published that if we go into a constitutional convention, or that becomes an option again and we start doing amendments more generally, that the right wing is going to pass all sorts of crazy amendments. And so I think the disads to that counterplan probably maybe even outweigh the credibility disad. There's also some good link turn evidence on both sides about the question of court credibility. So I'm not sure what the net benefit would be that the AF doesn't have good offense to. I do think the big advantages question is, I think the big advantages question is a good one. I included in the file that I just uploaded a couple different cases that have pretty decent sized advantages. Things like war on terror, debate, which is a central immigration question in most of these debates, in my opinion. Advantages about the supremacy clause and whether or not the president has the right to or has complete control over foreign policy. That's a really big advantage. One of the cases in the second document talks about E-Verify and would make it illegal if you overruled it, would arguably make it impossible for the states to require E-Verify. The impacts to E-Verify bad are pretty big. So I think there are big advantages. I have some further thoughts on that, but about how education is probably more important than the big advantages as well. But I think the wording question is important. So we decided on overrule as opposed to overturn wording, and there might be a place in the doc where that's messed up, but overrule is Black's Law dictionary for reverse the holdings. And so overrule, in my opinion, is a mass noun, aka if you overrule the decision, you reverse all the holdings. So that would limit it to the reversing advantages off of reversing all of the holdings. Whereas a holdings wording, so overrule one or more of the holdings, allows you access to more process ground on the AF, allows you to overrule one holding and not another, which you can have a smaller AF if you so desire. I don't think there's too much advantage to that, but I mean, if that's what people want, that seems reasonable to me. So, I don't know if you want to hear the spiel about the importance of the courts AF, or we want to.
Yeah, if Sarah had something to add about that.
Yeah, definitely.
Sure. So I know that this meeting is not to try to argue for one topic over another, but to do wording things, right? I think the most important wording thing that we should consider is that there's just a lot of uncertainty with regards to immigration policy, so long as that policy affects the number of immigrants we allow into the country. The biggest one being that if Trump doesn't open borders by next season, then it would theoretically be an inherent affirmative to just go back to March's status quo. I can't imagine that that would be good for the lit base, since there's only going to be some news articles instead of in-depth academic discussion. So my biggest argument for courts or a similar topic would be that it allows us to talk about cases that aren't going to change because of the pandemic, the election, or just Trump doing things. That's my 2 cents.
Yeah, and so I'll just go down the list of people that I have here. So first I have Ravi, and I'll just blow everybody's hand as they go.
Cool. So for me, I guess I'll be brief and kind of touch on like two kind of areas that have been discussed. The first, I kind of disagree that the SCOTUS topic doesn't allow room for big stick affirmatives, just because there are a couple like cases that have been identified that kind of have roots within trying to get the U.S. more in line with certain areas of international law, whether that be in terms of like refugee statuses or at least in terms of just kind of like treatment of immigrants, so to speak, right? So I think if nothing else, you could probably have like some leeway into something like soft power type advantage you can go for. There's room for it. It's just going to take a little bit of work on the level to get there. Beyond that, I guess I will try to kind of engage the issue of like test case fiat with an open mind. But to me, I'm just kind of like not understanding just from myself, like what the warrant behind test case fiat is and why it's so persuasive to people in comparison to some like the more historical examples of SCOTUS taking action in an indirect way in unrelated cases, like in the discussion Facebook page, like I brought up things like the Caroline Parks case, for example, right, where the court ruled on something that was an economic issue, but signaled things for issues that deal with more of like personal liberties within like this footnote, so as an example. So maybe that means like affirmatives under this topic could be that new footnote for immigration, so to speak. But I guess I would just like to hear more over like what the warrants behind test case theory are and why the examples that I've, like, for example, provided don't necessarily resolve a lot of that concern.
Luckily, Jared is next.
Great, because then I won't forget what Ravi just said, because Ravi, the example you just brought up is the reason why the negative needs to know the case. Because if it's just going to be a footnote or a dicta that signals and they're going to claim their solvency off of that, that's different than specifically reversing precedent. The notion that overrule just necessarily reverses all precedent is not true. So the test case fiat argument is more than just a fiat concern. It's a concern about case debate, that we lose case debate because we're debating, like we would not know what the holding looks like, what the fact pattern of the case is that's used to overrule the previous case. So we're going to get a list of cases. Hey, the United States Supreme Court should overrule one or more of the following 5, 6, 7 previous decisions, and the AF just gets to say, yeah, we overrule it. Or do they get to be more specific? Do they get to overrule one holding? But we don't get to actually debate. So like when Dustin's talking about the education, about learning about the courts and why that's important, we're skipping past all of how it actually works. And the negative doesn't get. So the example that I've brought up a couple of times is Korematsu. So the Korematsu decision, where the court upheld AR's right to intern Americans, was overruled by Trump v. Hawaii, where the court upheld Trump's travel ban, right? So it wasn't just, so if in a world where we debate Korematsu as a case that says, hey, the Supreme Court should overrule Korematsu, the AF could just argue we should overrule Korematsu because internment camps are bad and not have to defend what they had to do in order to overrule it, which is uphold a Muslim travel ban. So the neg loses out on understanding whether or not how those holdings actually function to overrule. We don't get that debate at all. The AF just gets to assert that it will be overruled. They don't have to talk about how that happens, why it happens, just that it should. So we don't actually have a solvency debate, and the neg loses out on disadvantages. But I don't want to rehash the whole test case fiat. My bigger concern is I haven't seen a compelling list of cases that wouldn't be better handled through a policy topic. So if we want to talk about refugee and asylum status, let's talk about the policy rather than trying to achieve that through a court signal, which would then ultimately lead to Congress having to pass a policy anyway. Yeah, I've said a lot about that. I'm not voting for a SCOTUS F. I'm just not voting for that. So the test case fiat argument will be very persuasive to me, despite the notion that it's not persuasive. It's extraordinarily persuasive to me, and it has been. I mean, yeah.
Nadia?
Yeah, I think we can say that hell probably froze over because I agree completely with Jared on this. Like test case, you need to have a test case, not just for the simple fact of giving the negative the chance to know exactly what grounds you're doing certain things on, but also to ensure solvency mechanisms, right? If you don't, like, we're pegged into a pretty bad hole right here with the SCOTUS resolution. Either we require a test case, which tells us exactly what we can use to justify the overturning of a resolution. Therefore, we can get solvency based upon some regular time frame, or we have to just assume that we can kick out of whatever thing we actually want to do and just arbitrarily overturn decisions at any one point or time. But that is an entirely new presidential there's an entirely new methodology to engaging with the SCOTUS, like the SCOTUS question. We have SCOTUS debates all the time and partly, and like test case fiat is a very important thing to generating real link offense for even your most generic of disads. I can't in good faith vote for like a resolution that doesn't have this kind of propositional like solvency mechanism for the ALF. I also think that one of the other big problems I have with SCOTUS in general is that you don't get a lot of ability to actually change anything by SCOTUS overturning a policy, especially because the way in which laws can overlap or interplay across these decisions are made means that there's no way that you can actually guarantee that you're actually going to do the thing you say you do, or that you can ever achieve a real benefit because SCOTUS declared something unconstitutional, right? Like, you can't, like, you can go ahead and say that the United States can't detain immigrants unlawfully in detention centers all they want, but we already have laws in the book to say they can't do that, right? It would just make murder illegal twice, which never solves anything.
Okay, I'm gonna go with Tess.
So I think that while SCOTUS resolutions do seem like I think test case fiat like makes sense. We should have a test case. You shouldn't be able to just like make something up and then be like, oh, a case will come up. So I think that test cases are necessary. But I think for people that really want to have like the courts debate can do that on topics where it's USFG action because the courts are a part of the federal government. I don't know if this is just me, but the idea of debating about the Supreme Court, just like, I don't want to do that. Like, that seems like a world in which we are not getting into the depth of the topic of immigration, but more of just like, I learned more about the actor of this topic, which for me doesn't seem to be in the same lines of the topic paper, but that might just be what immigration necessitates because it does require more, like passing an energy policy isn't as legally nuanced as something like immigration, but I just don't want to do that. So that's my 2 cents. And with that, I have to go to church. Bye, y'all.
Go to online church, right?
Yes, online church.
Shanna?
Yeah, so I have a couple things. And to kind of preface all of these, I hate the idea of a SCOTUS topic. Like, it puts me in a point where I would much rather boycott an entire season than actually participate in it. But I don't think Megan would let us do that. So there's a couple of reasons that I say that. And the first is that I feel like if we ignore the fact, and I think Jared spoke to this, if we ignore the fact of that you need to have a test case or, anything like that, that we're losing a lot of educational value to debate and learning about how things work and how things process. And I think that it would be a very big disservice to our students to be like, hey, you can just do it. Like, just say it'll be done by the Supreme Court, which has a very long process of all of its stuff that it does. The other thing is that I worry about what the expectations would become for plan text. Like, how long and how detailed would our plan texts be, especially when you think about that what is really key, not just having what test case you're ruling on, but also what are the grounds for the decision. which are 100% required to be put in the majority ruling paper. What was the vote count? Who was in that vote count? Because having what the vote count is, like a or not five, whatever. Having you know, a unanimous decision versus a split decision has a huge variability on the longevity of the case and that decision standing for a lot longer. And then also, you know, knowing exactly who votes yay and who votes no can play into court credibility and advantages and disadvantages, right? Additionally, if we do SCOTUS, it allows for us to very easily get away from the immigration topic in general, because there's a world in which advantages can be so easy to write that are about either you know, court legitimacy for a certain level of the appellate courts, writing it as, you know, a pseudo-politics advantage of you increase the likelihood that X judge gets more weight so they can push through more of their plans through, you know, X, Y, and Z, stuff like that. I don't know. I can say right now that there's a very good chance that if affirmatives didn't have a plan, didn't have at least at the very minimum a test case, I would probably refuse to vote AF, period. That's all I got.
Okay. Does anyone, by the way, have like wording comments? Like just like beyond like if you like courts, AFs or not? Are there like particular things with like the wording of this resolution that you feel like should change? I'll still go in order, but if you have those, could like you front load some of those comments too? Justin?
Yeah, so I can start with the wording stuff. So I think that considering the NDTC topic that happened before and the list of cases that were used then, I agree with Dustin that in this topic, it should definitely be an overrule. The other thing I think that's important to consider is that a lot of these advantages and counterplans get debated out way, way better in the law review literature than they do in most policy debate literature. Like when you read a law review, it's like structured offense arguments and disads that are created in a way that are almost perfect for cutting cards. So if we were to have a court's topic, I think keeping in mind that, you know, test case stuff and other issues are important to people, the overrule wording would actually capture a lot of literature that the law review students who are editing and writing these law reviews actually use in their discussions about these cases. Very rarely, unless it's an analysis of a SCOTUS case that's already happened, is the test case highlighted at the forefront of the article. It might be mentioned in a footnote, and yeah, I get that that's a concern, but those debates happened a lot less often than I think people remember, because we tend to remember the debates that kind of fell apart in that year than the ones that actually went well. And a majority of those debates centered around the kind of like way in which SCOTUS decided to overturn that. And most of the law review articles are written on grounds basis, which means that overruling a particular holding or overruling a particular case allows you to set up a justification, which then becomes the internal link mechanism for your process advantages. And I actually think those debates were quite good, given the like weight of the advantage that the AF gets to claim within the courts versus some sort of specific disad that the negative gets to get, instead of just the disad or the counterclaim capturing 100% of the AF and it basically being over after the NC if the AF doesn't have offense. Additionally, I think that having a list of cases is really important if we do go with the court's topic. I don't know that we've made a decision on list or not list yet, but as a wording choice, having a list grounds it in a lot of law review lit that's easier to find, instead of just saying the Supreme Court should substantially reduce restrictions or something like that. I think staying away from the like more policy stuff. That's kind of my 2 cents for now. I'll chime back in if I have anything else to add.
Scott?
I'm curious about the pros of as we were talking, I was trying to look at law review articles, and I haven't debated a court's topic. Just the nature of the pros when people are writing about overturn. Is it primarily that the decision was flawed on these grounds, or is there a robust discussion of the implications? You know, this would fix this, this would solve this.
Rebecca?
Yeah, I mean, I think for me, doing like a Supreme Court topic is definitely something that's really interesting. Just as somebody who plans on like wanting to study law in the future and doing something like that. And I understand here a lot of the concerns that coaches seem to be having with doing a Supreme Court topic, but at the same time, I think that doing like overruled, I think really helps avoid a lot of those issues. And I think that if people want to have like good cases, we'll have a test case that provides enough solvency to say that this can be done, and we'll utilize that mechanism to do so rather than just fiat that the decision is overruled because some magic reason that it happens.
Ravi?
Yeah, so for me, as far as kind of like wording questions for SCOTUS res, I definitely am in agreement with there having to be a specific list of cases that we kind of narrow it down to, just because in a universe where an affirmative gets to kind of any case, there definitely are a lot of cases throughout the court's history where they make very narrowly tailored decisions that are kind of confined to a specific set of facts. And I think that allowing an affirmative, and that's typically kind of what the court does because they tend to kind of cower their way out most of the time with it, right? So I think a list is probably necessary to kind of force the affirmative in defending something that's very broad and has actually some broader implications to it. And then I also agree with the questions of like overturn versus overrule as well.
Is it Salem?
Yeah, it's Salem. So for like wording, I agree there should probably be like a list of things to limit things in terms of limits. Besides that, I was going to talk about the advantage ground question, as well as I think someone was talking about why we need courts and why like a policy wouldn't be able to resolve some of these questions. So for advantage ground, having debated on the high school policy topic, I think there's no problem having any form of big stick affirmatives. So Wang versus Pompeo directly implicates the derivatives aspect of the high skilled immigration cap, which means you could have any high skilled immigration good type advantages, as well as that court action on immigration can directly implicate the plenary powers doctrine, which could implicate things like NFU. Additionally, the Kerry versus Den case could have some Chevron internal links because people read that in high school. And I guess talking about why why some of these questions cannot be resolved by a policy, which could also be a solvency deficit to things like the amendments counterplan or a Congress counterplan. So the Kerry versus Den case in particular revolves around the fact that Den allowed the courts to restrain a judicial review and cite consular non-reviewability to refuse a review for a visa denial. So it allows for consular officials to basically just go and say, like, they can deem any visa unfit to be reviewed based on their own interpretation of it. So there's a lot of literature saying that having this broad interpretation of deference to the DHS as well as consular officials could implicate things. You could have a deference advantage. I don't think policy options could resolve some of these precedent-based issues, but yeah.
Justin?
I don't think you lowered my hand after my last comment.
No, it's the other Justin. That's the other Justin.
Perkins, yeah.
I almost did the same thing when you called on Kirk earlier.
Yeah, sorry,
So yeah, in the interest of like wording and like, you know, I'll be upfront in saying that I don't think that this resolution should be on the ballot. Like, we should not give voters an opportunity to stick us, for lack of a better word, with this resolution. But you know, in good faith and leaving it up to democracy, I brought up the notion that maybe we could somehow resolutionally limit the grounds by which the overrule would happen. And you know, Chad pressed me on it and I had like 0 other comments to back that up. But maybe that might be a discussion that sort of at least prevents, like, if this is going to be on the ballot, like, we've just decided that like we're waving past test case. Well, cool, then maybe we can at least limit the sort of slippery slope, big stick apps where all of a sudden I overturn a certain holding and now I'm solving for capitalism or something.
And I think Jared has another comment.
Okay, yeah, one more comment on this. And this is just generally, I think that we should consider beyond, once we move on past the SCOTUS resolution and talk about all the other resolutions, I think that this comment is important, but I think it's particularly important on this SCOTUS discussion that we don't just write the topic for the top 10% of our debaters, right? We can always say, yeah, bad debates are going to happen, but so are good debates. Good debates are going to happen. I'm highly concerned for our novice debaters, for our regional debaters, for our folks who primarily do IEs or Parley and only every once in a while do LD, who do their LD debate primarily off of a packet. We're not serving the large body of our students when we write really technical topics that require really technical research. You're putting your coaches in a really difficult position. You are thinning out the pool of novice debaters, right? So yes, I understand bad debates are going to happen, and I'm going to see like 80% of them. But good debates are going to happen, whether, as well. Those top 10% of the debaters are going to do an awesome job and come up with really cool cases and get into really particular interesting advantages and all that sort of stuff as well. Let's keep in mind that we have a large body of debaters, not just the really awesome debaters that we see in the out rounds of our major national tournaments. I have to watch these debates amongst novices in Northern California a bunch of times. And my students have to debate in front of judges who don't see debate very often. And like, that's supposed to be one of the selling points of LD, like NFA LD. I don't have to have a law degree to judge a debate.
Dustin?
Yeah, I suppose just I'll say that there's a lot of literature in the file I uploaded, like lots of links to law reviews, most of which are written at an undergrad level, more or less. And I just literally put in this case, overturn or overrule, and came up with all this literature. So I think that it's like pretty accessible. People should learn about a third of the federal government. And I don't think that the advantages won't be, well, we save some people from a detention camp, although as the central ones, it'll be broader and more important questions about the nature of our policy. And I don't mean more important in terms of like the immediate value, but in terms of the broader impact. I don't know, that's just kind of my 2 cents on it.
Justin, then Noel.
Yeah, so just real quickly to respond to Jared's concern, I actually think that the research for these cases is way easier sometimes than the research for policy cases because, like I said before, the law review articles are structured in a way that are both orderly and easy to read. And I mean, most of our students who want to go on to pre-law and stuff will be taking a con law class anyway, and so kind of familiarizing them with law review literature ahead of the time will help some of them. Yes, it's a small number of students. But also, I think that the early cases can be much better developed to have clash with one another because the law review articles cite one another more often. It's really easy to search in either Lexis or on Google Law Reviews to find different articles that literally just answer one another back and forth for 3 or 4 issues, which create better clash and much better debates for novices because all they have to do is understand one article and how it responds to the other articles. In a lot of ways, it was like the nukes topic on the NDT when everybody was writing blogs that were answering one another. It was just like, oh, in response to so-and-so's argument number 1, here are 3 responses. And so it almost generates a better world for novices because they don't have to construct the rebuttal framework that they would normally have to, which is some of the hardest things to learn as a novice. So that was just my 2 cents real quick.
Noel, then Ravi.
So I guess prefaced with I'm like a teeny bit out of my depth in this conversation insofar as I'm super unfamiliar with the court's topics in general. I've barely skated by not debating on them and judging on them thus far in my career. But secondly, I think that at minimum, I think that it would be super interesting to have one. I think there's a lot of concerns and I think that they're all valid. Some people, interested parties, though, maybe we could have a proper court paper, just because if we don't decide it now, we could do it in the future. I think it might be interesting. So I'm definitely buying the arguments insofar as we don't get this sort of debate literature a lot. Those law reviews aren't so bad. Most of them aren't so dense that it might be all right. And I'm of the opinion that the fact that, like, because I don't have a political science degree, just did debate, that was my, like, the thing, have absolutely no context for a lot of this conversation, it probably means we should try to be exposing kids to that, because I certainly avoided it. And that might not be good, but I think at minimum, these, even if we decide that it's too much for this already pretty, like,
much.
It's a topic, is what it is. Yes, but yes. If we decide that it's too much for this immigration topic, it might be beneficial to hash this sort of thing out in the secondary topic paper next year, and maybe next year we can have this topic that several people in the community seem to really want. But otherwise, I have no opinions. We should have a list.
So
yeah, Ravi, and then I'll move it on.
So for me, I'm not unsympathetic to the idea of like accessibility towards like the topic lit in the context of a SCOTUS res, but I also think that it also kind of depends on the case you pick, right? And depending on the cases you take, it might list of just because, like, sure, if you were to ask like a first-year freshman novice competitor to kind of deal with a case involving something like Lawrence v. Texas, right, which comes down to a very nuanced definition of a word, that can be a very difficult thing to hash out, right? But I'm kind of looking through a lot of the cases that were kind of posted within the LD discussion group, particularly ones that were posted by Dustin. Many of these cases seem to follow kind of a common theme of having like your typical national security, these civil liberties type debate, to where at least as a theme can be kind of easier to hash out for debaters. I also think that even the ones that kind of fall outside of that scope, like the National Labor Review Board case, right, kind of is like your typical immigrants good versus bad economy debate. So I really think it, one, depends on the case, and two, probably is the reason why a list is a good idea.
Yeah. So the only things that I'll add, because I think I've like pretty much everything that's been said kind of exhaust my thoughts. In terms of wording, the concerns primarily there seem to be a list. It seems like there's already a list that's been given. And then there were 2 added today. So I definitely think there's no vision of this topic that doesn't include a list. I think the larger question is, if we included this topic, which one of the cases that have been listed so far would be on it? All of them? None of them? So like maybe like the folks who can, you know, look at that list and like think about it. I mean, obviously I will too. Maybe that could be like some discussion moving forward. On the like test case thing, I feel like it's really just kind of it almost seems like an opinion-based thing. Like, and that's kind of hard to resolve in an online forum or even like any forum. I guess I just like, I have these memories of 2006, 2007 being like a sophomore, I think, maybe a junior. No, I'm pretty sure a sophomore. And like rolling up to say like the University of Kentucky tournament, just to like watch rounds, because it was like 2 hours away from my house. These are like NET rounds, and like me like kind of having the opinion, yeah, test case going to be a big thing. And then just like seeing like 2 ACs like Julie from Emory just dunking so hard on test case. And then like by Wake, looking at sort of like the list of sort of like NCs and being like, oh yeah, everyone stopped running test case because like all those 2 ACs just destroyed it. Those are like kind of my memories of that. Doesn't mean that that's like the only way things could go down in LD, but I think like maybe some of the people who are like saying, oh yeah, test case, not a thing. It's maybe more so just because like we have this memory of like that fear existing and then it being like, oh yeah, no, 2 ACs destroyed that thing. It was not a big deal at all. So that's better or for worse. Doesn't mean that that was correct. Let's move on to the next slide, because I think we've talked about SCOTUS quite a bit. Okay, so visas. So I think visas has had less discussion than SCOTUS, mostly because I think that everyone kind of agrees that visas has I mean, I don't think anyone kind of like disagrees that visas should be debated, or at least like should be offered. Jared, your comment is really funny. That's definitely very true. So it seems like the major sort of like debate about the wording comes down to the idea of issuance. So if you looked at the resolution, basically what Jared and Justin worked on sort of included this wording about increasing the issuance of visas. And their intent, which I think is really good, is to sort of like force the affirmative to defend the government actually gives out more visas, as opposed to just like lifts like the cap or something, and then sort of claiming advantages based on that without ever defending they actually give out more visas. And the issuance wording, I think we're still like working on, because one potential problem is that in order to issue visas, there have to be applicants. Potentially there can be problems with the affirmative not being able to sort of like increase the number of applicants, and then that's an effects question. So I don't know if Jared or Justin want to kind of like talk about, Justin Perkins want to talk about kind of where they are with visas and directions, etc. Yeah, Jared, you can go ahead.
Yeah, I was trying to unmute, sorry. So the issuance versus increased number of, that's not something we were particularly married to. We just wanted to put it out there as a possible issue, because I don't think it's a massive problem. I think issuance is a more limiting wording for the AF, but I don't know that that limit is particularly necessary. In the sense that the AFs that are allowed when you say increase the number of visas would be, so the example would be in 2001, we expanded our cap on H-1B visas to 195,000, and not all of those visas were taken. You could still claim some sort of advantage potentially about expanding the amount of visas available, and then sort of backpedal a little bit when the negative makes an argument and say, oh, but they won't all be taken. This doesn't necessarily mean a bunch more people immigrate. I think the amount of those advantages are extremely limited, and that the demand for immigration outstrips our number of visas by quite a bit in most years. So it wasn't something we spent a lot of time researching. It was just something that came up, and we thought maybe issuance might be a more limiting terminology. I don't think it hurts us either way from a wording standpoint. In terms of like, I don't think it forces us into that weird little effects area, in the sense that, I mean, if the neg comes up and says that you've got less people looking to immigrate than the amount of visas you're trying to give out, that maybe puts the AF in sort of a weird bind, but it's probably just a pretty good solvency argument for the negative. I don't know that crushes the wording of the topic. It's just kind of a weird argument that might pop up every few tournaments in a, I don't know. I think that the AF could quickly fix that in their 1AC for the next round and rewrite their plan text a little bit. So what we saw on the immigration topic in NDT-CETA was a lot, the start of the year was 80% H-1B AFs with a variety of different solvency advocates advocating for different number caps, and people sort of adjusting based on what the neg responses were. So that was the whole issuance versus number of. I'd be comfortable with either one. So if people think that issuance is too much of a limit, that's cool. We could just go with increase the number of. The visa types, I can, we'll have Perk talk to that because he worked more on those lists. What we put forward in our little working paper was you could limit the topic to solely immigrant visas, right? Immigration visas, permanent immigration visas, and that still captures a lot of, right? It doesn't, while it excludes the H-1B visa, it doesn't exclude all like work visas. So there's a lot of like permanent immigration visas that are employer sponsored visas that still get us that sort of like key to this industry sort of econ advantages that would exist. But we did a couple of versions of a wording that included visa categories. And then we did a couple of wordings that included just specifically, here's a list of visas that you could either increase the number or issuance of the visas. So just, hey, we want to do an app that's like purely get more people here for this reason, right? More immigration good. And also included the section of the wording that talks about expanding eligibility. So, you know, reducing restrictions on eligibility would deal with something we talked about last week, which is the inadmissibility standards. So you could, an app that would eliminate inadmissibility standards for particular visas or for a visa category. But you could do other things, right? So we did reduce restrictions on, so you can't just like add a bunch of like things on and say, hey, we're gonna make all these people. But what you can do is reduce the restrictions that exist that make certain people ineligible for visas. So, I mean, we are happy to answer any questions that people have about what we wrote.
Yeah, I'm going, Riley.
Yeah, so I'm gonna stay away from the FXT question really quickly, like because it's been discussed on Facebook. I think that if the decision is that we want to avoid the FXT issue, which would mean that the resolution would be the version that says increase the number of and/or reduce restrictions and/or reduce regulations on the eligibility for, or something like that. I think a better version of that is reduce regulations on the issuance of. Just because it's more elegant, it avoids the and/or clause. It avoids kind of the proliferation of a bunch of different verbs into the resolution, which makes T debates messy. And I think restrictions on the issuance of or regulations on the issuance of, the literature is pretty clear that that includes both kind of numerical quota caps and includes other forms of restrictions on eligibility, which are meant to be included in the second clause in the resolutions that are written on the doc. The second thing is on the visa types issue. I don't think it makes a lot of sense to me to like list the 3 different kinds of immigrant visas. I would prefer it just to say increase or do some verb to immigration visas. I think lists are bad unless there's a reason to have lists. I think that the claim that was made on the doc, which I think is true, is that the 3 different types of visas that they were proposing on the doc constitute almost all immigrant visas. If that's the case, we should just say immigrant visas in general and not bother with a list.
Can I respond to that?
Yeah, go ahead.
Okay, so on the first thing, I didn't have enough time. I saw your comment on Facebook about that, and I didn't have enough time to research that. My initial concern would be, and if the research shows that this concern is unfounded, cool. That I think that there's a difference between issuance of and application for. So the expanding eligibility issue, I don't know that reduce restrictions for the issuance of would, I think that there would be ways for the negative to sort of exclude things like getting rid of inadmissibility standards. Or I just think that there would be, that it's while wordier, it is clearer that we want the AF to be able to expand eligibility. And because I think you're talking about from 2 different sides in terms of that, but I could be wrong about that. But as far as the second thing, I definitely disagree with that wording in terms of why we would include a list, because they could theoretically all be immigrant visas. Like there's a T debate there that the AF will win a bunch of times, but I think that making the list, one, is not a problem because it includes a lot of ground for the AF, but also makes it pretty clear that those are what we mean by immigrant visas, and that you avoid the trap of the singular Cuban baseball player AF that's just here for a season or something like that. So or travel visas that somehow somebody's got a card that says that it's technically an immigrant visa or something like that. So while I as a judge might certainly prefer say, hey, no, this EV comes from the DHS that says this is what an immigrant visa is, that's not true of a lot of our judges, and you're going to find a lot of AFs that start swirling around that. So I don't think it's that bad of an idea to just say these are the visa categories.
Scott? Scott, are you there?
Scott is muted.
Scott, I think, there you go.
Yeah, are the caps legislatively created? And is there a concern with sort of, I know it's should-would type arguments, but no matter what the legislation says, you've got William Barr interpreting the legislation. Would you anticipate that that would be part of the debate or problematic? So
Yes, the caps are legislated, but William Barr destroying the Constitution is probably a problem for every resolution.
Yeah.
Yeah, the caps are usually through legislation, but the enforcement of admissibility standards are usually DHS in coordination with the State Department.
Right, that's an enforcement question.
So either,
and an enforcement debate is an interesting. I think it's a debate, right? I think that's net ground. Policy argument, it won't be enforced. I don't know.
And would it be a USFG agent?
Yes.
Would you be okay?
Justin Kirk.
So I have a couple of questions. The first is if there is an issuance type of resolution, what if the AF picks a visa category that has not yet met the cap and just issues up to the cap and not over, which would avoid any congressional action and avoid any sort of congressional politics disad? The second question I have is if you expand eligibility without raising the cap, wouldn't you just increase the demand without changing the supply of available visas, thereby avoiding any actual action by the affirmative? You could expand eligibility and have 1 million people more apply, but if there's no more visas to go around, if you don't actually mandate a congressional raising of the cap, how does that affect solvency, et cetera, et cetera?
I don't know what advantage you would claim off of that app. I mean, I guess you could do that without, right? So if you can find an advantageous app that just expands eligibility without increasing the number of immigrants, I don't see why we shouldn't debate whether or not that's advantageous. But in terms of just increasing to the cap, that's just going to be hard to predict. And again, like I said, that could be just an argument why we don't use issuance. We just say increase the number of.
Yeah.
In most years, that cap's being met very early in the year.
Also to pipe in, on the first question, if there was a cap that wasn't being met, ostensibly the reason is that there aren't enough applicants. I don't know that the app.
More about President Trump's collision course, with the scientists on his.
I don't know that Trump could.
Dr. Anthony Fauci tonight, specifically on testing capacity.
No, it's fine. I don't know that we could just create applicants, if that makes sense. But yeah, I think that's definitely an interesting question. I have Noel, then Perkins, and then Riley.
Oh goodness. I think I hit raise hand back to voice the idea that I was in I liked the idea of our last week's conversation with trying to box out the H-1B visa stuff, just in the favor of having some debates about some people who aren't coming here for economic reasons, or not those specific economic reasons, for the job stuff, the brain drain disads, because I don't think those are the crux of what we want to talk about when we're talking about immigration. I'm definitely in favor of that. I also am super partial, but what I believe what Jared was saying about somebody was talking about why having the list of types of immigration, whatever the term of art was, is probably good, because I would definitely find some squirrely card that says something is technically an immigration visa, and now we have to debate that squirrely thing. And I think that there's a conversation happening kind of about whether or not people are going to be able to win that that topicality argument, in terms of oh, it's a term of art, we could win that T. But I just didn't see term of art was used a lot on the cybersecurity topic, I believe. It might have been the bioprospecting topic, and those words swiftly became meaningless. And there was a couple arguments even on this previous year's topic where, oh yeah, energy policy means this precise thing in this context, but it kind of devolved from there. And I don't know if that ever we always hope that at the start of the year, and I don't think that ever happens.
I think the problem with the cyber was that complex catastrophe means there's just no limiter on the word complex catastrophe.
Yeah, that was the problem with that one.
Because it
Yeah.
wasn't as if like no one could win the critical infrastructure component. Everyone could win that. There's a freaking list from the DHS. It was that the AF would just be like, I'm not going to specify if I am protecting critical infrastructure or preventing complex catastrophe. Whichever one you read, I'll claim the other one. Which, yeah, definitely made T like really
Yeah,
difficult.
that was another problem with that topic. Maybe we could have one without and or.
Yeah, it was. I would say that it was probably the most frustrating topic I've ever seen in terms of actually winning a T debate that felt reasonable, because the AF just always had like an incredibly BS, yeah, but the topic says I can do whatever I want kind of response. I thought energy policy I would give like a C plus B minus on limiting things. Definitely some things got limited. Definitely some things that weren't energy policies didn't get limited. But not quite as bad as complex catastrophe.
That one was super bad. That's the word. That's the far end example.
The topic record
of times. Yeah, but I'm definitely in agreement of like the listing. If we want to specify, we really should just list types of the.
Yeah.
I think it was immigration visas.
My interest comes from, I think that it's, I guess, interesting. Like I guess to me, I'm like, I would enjoy watching that debate. Like I would enjoy watching people be like, immigrant visas are X, Y, and Z, your W, and then a debate about what the word immigrant visa was. I think that'd be a fun debate. But I guess like it's fine if not everyone thinks that that's like a fun round. I think that'd be fun.
I mean, you always have an ally in me on that front, Chad.
We've got Justin Perkins, like the restaurant.
Yeah. So yeah, I guess I can just speak to the, I guess if we're kind of moving towards into the discussion, I can speak to the visa types. So the how I generated the lists were, I kind of kept what we talked about last week, focusing on like it just being the immigration visas. And yeah, the reason I broke those up was I just wanted to kind of silo out those three types of immigration visas. Like I said in the Google Doc, they capture most, if not all. There are some other types of quote unquote immigrant visas that are not family sponsored, employment sponsored, or the diversity program. So to the visa types, the one that was kind of a stickler for me that I kind of wanted to include was the diversity program. I think it's kind of a cool program, and it kind of solves, it allows you to talk about countries that are not prioritized in immigration visa allotments as is. And I think that that's just kind of a cool area for the AFTA debate. On to the when I moved to include some non-immigrant visas, I kind of wanted to just limit it to just the temporary workers, because I think that just has good, robust AF ground, but also is, which was brought up last week as well, is it's a good place for beginning debaters or recruiting or new recruits to kind of get in and have a handle. I think the H-1B literature is pretty robust and large and easily findable. So when I broke it down to the like actual distinctions and the like letters and types of visas, I pretty much just kind of randomly chose ones that I thought were kind of cool. The one that I had struggled with including was the J visa, which is for doctors and physicians, which would kind of allow us to talk about the ways the AF can actually help us deal with Corona. But doctors and physicians are also eligible for H-1Bs. So I just kind of didn't want to ugly up that part of the list anymore. But again, I'm not really married to any of the types in the list. So they're definitely open for debate, and we can definitely tweak that part of the resolution.
Riley?
Yeah, I just want to say I'm like very sympathetic from 4 years of high school public forum to the argument that judges don't vote on topicality. I think that this is probably an empirical question, which obviously not having done the event, I don't know the answer to. On a kind of completely different question, this is a very small thing, but the final resolution should the final resolution should say family sponsored and employment based, because the term employment sponsored is just not the term that's used in the literature. They call it employment based visas and also should use hyphens. These are very small wording things, but they're just like important to get right, obviously.
Yeah, we would clean that up for sure.
Definitely. Dustin.
My only concern, I'm on board with like the list or the more vague kind of wording, like immigrant wording. My only concern is as we head towards smaller and smaller visas, the net ground gets dicier. So like, you know, if we do like a diversity type visa, I mean, I guess maybe there's some counterplaying ground, but I'm not convinced that like the neg will have meaningful things to say in a lot of those debates that isn't like quasi-racist, you know? Like, want to prevent that as much as possible.
Yeah, I mean, again, I think that's a larger problem of the whole topic. But yeah, the diversity visa, I think, I mean, there's some interesting AFs, but I think that depending on the AF, there will be some very interesting case-specific debate that will happen on, you know, what is the rationale, what are the advantages that the AF is claiming off, right? So if you just do a straight up numeric expansion of the lotto for the diversity visa, like we're just going to allow more diversity visas rather than perhaps expanding it to other or changing the definition, reducing sort of the restriction on what constitutes a lesser represented country, because one of the things we see with the diversity visa is it oftentimes doesn't live up to what it's supposed to do in the first place. We get folks getting diversity visas from countries that are already well represented. So I'm certainly sympathetic to the idea that neg ground is problematic on some of the visas, right? Like, so the translator visa AFs are going to be hard to debate from the negative side. But I think we're going to run into those sort of AFs on every version of this topic. So I don't know. Like, could we just take the diversity visa off the list? Possibly, yeah.
Yeah, I mean, or write the topic. I don't know. There's some T substantial definitions floating around too. But, you know, if there's like a specific disad rather than just some solvency args, I think that's kind of like.
Well, oftentimes when you find those solvency arguments, that leads to a case-specific disad as well.
Yeah, fair enough.
Scott, real quick.
Yeah, I was curious. I mean, you'd think that something like expand diversity visa would be sort of the heart of an immigration question, like let's welcome people in as much as we can. Is there a robust literature advocating for the increase in that? I mean, it seems like the United States does, compared to other countries, let a fair amount of people in under, you know, very progressive type conditions. And I just Googled, you know, expand the number of diversity visas and nothing pops up. It just describes how it's being attacked by Trump.
Yeah. Well, the diversity visa is just it's a lotto. It's like, right. So,
is there someone advocating for a bigger family reunification, expansion of that? I mean, that's pretty big.
Yeah, that's out there. There's definitely literature on that.
Is there? Okay.
But the family visas, right? The family-sponsored visas are different than the diversity visas. The diversity visas are you just win the lotto because you're in one of the countries deemed, and you get the visa.
So there are family reunification visas. And is there a limit on those in the status quo?
Again, this is more of a perk question because I kind of farmed the list out to him while I worked on the mechanism.
That's why my suggestion about the other direction, the United States has a very decent immigration policy despite Trump. You know, of course, I think there should be open immigration, but it just seems like most of the changes go the other direction. Except for with the courts topic, I think that's.
Some family-based visa. So family, if it's direct immediate relatives of a U.S. citizen, that is not a numerical limitation. But pretty much all other permanent temporary immigrant visas, I mean not temporary, permanent immigrant visas are subject to numerical limitations, specifically the employment-based ones and the diversity program.
Right. And because of those limits, what we see is like backlogs of people trying to immigrate where it's taken somebody 15, 20 years to join their family here. So, I mean, I certainly think that there's a lot of off ground on more than just sort of the H-1B or business-related visas.
Riley, then I think we'll probably move on.
Yeah, this is just a random thought, but it seems like people agree that there's kind of a lot of off ground on all of these areas. And it's like unclear if there's net ground on like the family and diversity visas. There's like obvious and clear neg-lit bases on all of the employee sponsored visas. Brain drain is like the major dissad here, but there are other dissads that like people read when this was a PF topic, etc. And so I think that like if the idea is that we want to ensure that there's net ground, and in particular that we want to ensure that there's stable net ground while still allowing the AF to have like a diversity of topical AFs, that it might make sense not to limit it on the basis of like either allow most immigrant visas or allow most non-immigrant visas, but allow most employment-based visas and not allow visas which are not based on employment, because then the neg is guaranteed to have the brain drain dissad for every topical AF, but the AF is allowed to pick like kind of any employment program they want, which includes H-1B programs for novices. It includes kind of very nuanced small employment discussions, like AI was big on the policy topic, things like that. It might be like a better way to parameterize visas than immigrant versus non-immigrant.
So to speak to that, this paper was written after our meeting last week, and my understanding of the discussion last week was that a lot of people were wary of just focusing on the economic issues. So when this topic was debated in NDT-CETA, and again, my experience is sort of limited to mostly regional debate. The first half of the year, it was 80% H-1B visa cap debates, which fine if that's what you want. But my understanding when I went to write these resolution wordings was that we wanted to potentially avoid the topic being engulfed by just the H-1B debate.
Yeah, and I think it's really
important.
important.
Dustin wanted it for his students.
And I also think it's really important as sort of like front end work to like explore if other visa types are viable for debate, because it's like we know for a fact that if we include or have a resolution based on H-1B or employment-based visas, we know that's a debate that is like D's, maybe even like better than D's, maybe good. So like it definitely enables, I think, us to sort of like look to expand beyond H-1B, and maybe we circle back around and say, oh, the conclusion is there's not enough neg args or decent apps on such and such visa. Maybe we need to just sort of like make it about H-1B and employment-based visas. But yeah, I definitely think that there's sort of like from the old people a crying out of something on visas that's not H-1B, because likely most of us have heard it multiple times. I'm including myself on the old people discussion. So yeah, I'd like to move on beyond visas. It doesn't seem like anyone sort of like has problems with like a visas-based topic. So that's like good to know. So now there was, sorry about that, a proposal for a larger resolution. Something that would be sort of like closer to, I think, what the original topic paper kind of envisioned. And there's definitely sort of like wording issues with these that are already sort of getting hashed out in the community discussion group. But so yeah, basically interested here in comments related to the large resolution as a type, and then also potential wordings. These wordings, are they wordings that we like, etc. And wanting to give Darren or a rep from KCC a chance to talk about it.
Thanks, Chad. Yeah, so the paper, the proposal we wrote is on the Facebook page. I got it up there about 4 o'clock today. I think it's already at about 100 comments, so there's been a lot of feedback back and forth, which is good. A big proponent of this area just because I think it does go in the direction of what the topic paper was about, and I am not afraid of a big topic. I think there are a lot of good reasons for that. That's all listed in what we included on the topic paper proposal. So there have been a couple of new resolution suggestions talking to Louis from North Texas, and so I just want to read a couple of options that he's included as well. The United States federal government should remove restrictions on legal and humanitarian immigration into the United States.
Was that legal or legal?
Legal.
Okay.
And the United States federal government should remove restrictions on legal and or humanitarian immigration into the United States. So both would include legal and humanitarian. One would require both, one would require and or. Those are kind of at the bottom of that Facebook chat. So anyway.
Hey, Darren, I have a question real quick.
Sure.
I didn't get to read these comments. Is humanitarian immigration, is the intent there to include asylum, refugee?
I think my assumption would be yes.
Okay.
Louis wrote that, and I'm not sure if that was his intent, but my reading of it, my assumption would be yes.
Okay.
So the rest of our proposal paper really just kind of outlines all the reasons why I think a broad topic should be discussed and included. And I didn't see a lot of disagreement with that notion. So I think it becomes a wording question. So happy to answer any questions or field any comments people have. Just to let you know, I have a meeting I have to run at 8 o'clock, so I have to leave here in about 12 minutes.
Okay, we'll go Zach.
So I have a couple of things, and I made some of them on the Facebook page. The first, I'm actually going to go to Louis' resolutions that he kind of submitted. The first is, I don't know how I feel about the usage of the word remove. It seems like that would be kind of in the direction of eliminating and making it so that there is one AF on the topic. Otherwise, you get in kind of a bind. So I think that just a substantially reduce restrictions could be a better way of phrasing that one. The other one is, and this is the one that I kind of talked about on the Facebook one, is I think that the second resolution is done in a much better way. We kind of had this discussion earlier about, I think it was talking about adopting a policy or something like that. But the first resolution talks about how we should significantly change legal immigration policy too. And I think that we have kind of already covered the area of like substantially changing legal immigration policy could like result in a plethora of different things and ideas and concepts. And the research burden then becomes very, very big. Like I understand the direction of wanting to have a big topic, but I think that like in our format where we have like half the time of NDT-CETA, we can't necessarily flush out the ideas and the intricacies of different 1ACs and plans in order to like actually go through and do a policy that does something. I think that we should be moving more towards the second resolution that leaves out the idea of changing legal immigration policy to do something. I don't know if the second resolution is the way to go because I think that the two is almost implicit in it. With the use of the comma. So like, I don't know like where our middle ground is and our happy way of like making that. I like the idea of doing a big resolution. I just want to make sure that the wording is well done and doesn't result in us doing things like we had with Cyber Command or with energy policy where something had to be done and then we had to prove policy in order to prove our topicality arguments in the long run.
Jay Kirk.
Yeah, just one question real quick, which is on 1 and 2, what's the justification for saying change the policy first? Why wouldn't the resolution be just as acceptable saying the U.S. federal government should substantially increase permanent immigration, which would effectually change the policy, but wouldn't make you have to defend kind of an effects-based standard for solvency?
Yeah, we had that discussion, and I'm not sure I see the last part of that question as much of a problem with effects-based topicality, but I also am not opposed to your suggestion about changing the order really of the stem of the resolution. So I'm not married to that order one way or the other, honestly. And Zach, I think your comment about the 2 question, I think is, I mentioned this on the Facebook page. This was the discussion Nathan and I had. So I don't necessarily disagree with that either. I think there are some ways in which how we define policy changes, whether they be significant or substantial, or what that looks like to get out of some of the small apps, because the balance I think we should strike with a big topic is the super small apps that really do nothing to affect or change immigration on face. And so I think that's where we want to be when we're writing this topic or this resolution. I think that's where we want to have the focus. I think it has to have a change in immigration, but it has to be in a way that's, something you can point to as a legitimate, significant, substantial, whatever change, however you want to phrase it.
Yeah, so to speak a little bit on from a theoretical res writing perspective, the reason why you include that first part is because the sort of like the neg can make sort of like this effects argument, to me, is not as bad as if the resolution just says the U.S. federal government has to substantially increase permanent immigration. Oftentimes, to do something like that, to increase permanent immigration, you have to do sort of like some other small things that are probably peripheral to the action that actually sort of like achieves your solvency and your advantages, but are quote unquote extra topical. So to give last year as an example, if the resolution just said increase funding to wind energy, well, a lot of the apps would require you to do things other than just giving money to wind energy. So to like implement an energy policy component is to give the app a little bit of wiggle room on taking actions that are not sort of like the crux of the topical action that you have to do that the neg is attacking, but don't make them extra T. And then the neg always gets the guarantee of, well, okay, they have to increase funding to wind energy or the energy types, but maybe there's like a little bit of something extra. So I mean, and I think there's debate back and forth on res writing and what's good or bad in terms of the elegant, what's better and more elegant. But yeah, I think that's the justification for it. You give the app the cover to write plans that represent what the lit actually says. I think Ravi had his hand up.
Yeah. So for me, although it's not necessarily my favorite genre of res, I'm not necessarily opposed to having kind of like a big tent resolution that we can just kind of have an option to vote for. I think that might just be a good thing, just have some diversity with regards to how we word the reses. I think that I would probably lean with the potential in the direction of resolution number 3. I think the one thing that we'd want to be really careful, I'd hope we'd be very careful about, is just the wording as it pertains to specific types of immigration or immigration areas that we talk about, right? Where each thing that's listed has a very accessible definition in the literature. So for example, on the current topic, right, it isn't always easy to like have a clear, distinct definition of what, say, a solar energy sector was, for example, right? So on this particular res idea, I think that something along the lines of having very specific terms of art as it pertains to immigration area that has a clear definition is going to be pretty important.
Zach.
Yeah, just a quick question, Darren. What makes this like specifically different than the high school resolution from last year?
I think there were a number of things we tried to build in to make it so, like, one of the problems we identified in that paper is that the high school topic only had one modifier, which is part of the reason why we included two, was the modifier that just allowed you to reduce restrictions or to do something that didn't increase on-face immigration, whether that was effectual or whether it was actual immigration increase. And so I think that's an important distinction. I also think you want to, and again, these wordings need to be perfected, but I think the wording needs to go in the direction of doing a couple of things. One, increasing that immigration, not allowing for small apps, and I would be in preference of not allowing the small apps, especially that deal with like non-permanent status or non-permanent immigration. And so I think that's where we could narrow that focus. But I also think this topic area gives an opportunity potentially to have some of the courts ground that some other people are desiring.
Sorry, Jared.
My main concern, like, I'm not necessarily a big fan of large topic. I want to make sure that there's like clear limits because I think that this, anyway, my main concern with the writing of the large topic is, while I understand, Chief, your rationale for needing that second modifier, what I commented on your post earlier on Facebook today is that you've got, in one instance, you're mandating the policy change, which is fine. That's what we debate about is like what mandates should be in our policies. And then we debate about the desirability of the policy and the workability of the policy. But your second modifier mandates the effect, which is what everybody's kind of worried about. And whether that makes the topical effects topical, you've mandated the effect of the policy, and that's problematic because it puts us into a really sort of tough situation, not to sort of the solvency or topicality debate. It gets a little screwy, and while I don't necessarily have a solution like wording in my head at the tip of my tongue, I think that's something that we should work on. I agree with the idea that if you want to make a large topic focused on like people coming to the United States, right? That's what you want your large topic to be focused on, that you need more of a modifier than reduced restrictions on immigration, that there's got to be something different there. But I think we've got to do it in a way that doesn't mandate the effect of the policy, that we look at actually, you need to change the policy that deals with this question of people immigrating to the United States.
Yeah, that's a valid concern. I think somebody spoke to this earlier. I think the nature of this topic, if we want to talk about immigration to the United States or increasing immigration to the United States, the nature of it is going to force a lot of effectual topical plans, regardless of what the wording is. But I'm with you on that. I think that can be hashed out. I also think I'm intrigued by these wordings that Louis suggested, and I had just seen them before we started the discussion of this resolution. So I want to take a look at those and do some work on those after my 8 o'clock Zoom call, which will be over at about 10 o'clock. So I do apologize. I need to bounce out. I think Nathan's here if he has other questions, but I'm certainly plan to go back and look at this video once it's uploaded to see if there was other discussion points that were germane to the writing process, because I think it's a good topic, or I think it's a good discussion about this topic. And so I appreciate that, but I do unfortunately have to run another meeting, so I have to go. But I'll also engage people on Facebook later tonight. I will be probably up till 3 or 4 in the morning, so feel free. All you'll be doing is interrupting my Seinfeld time. So thanks, everybody.
All right.
All right, thank you. Justin Kirk?
Yeah, so my biggest concern about limiting out temporary worker visas is if they were already thinking about excluding H-1B visas, then that means we also exclude things like temporary ag workers and forestry workers, which was the other big advantage area on the NDT topic. It was either big H-1B cases or big ag forestry cases. And my concern is that if we have a big topic and don't include either of those, then we're not really going to have a very large topic. It's going to be a bunch of very small visa areas that we can expand, like family visas, et cetera, or diversity lottery, that doesn't really have the generation of good AF advantage ground to outweigh the generic topic disab.
I see Scott.
Yeah, that was what my question was directed at as well. term immigrant has very particular meaning in the legal sense, but in the popular literature, it's very broadly defined. So would it be acceptable for people to have that broader definition, and then those concerns would not be so serious?
Jared?
Just to answer Jay Kirk here, what we found there are a lot of permanent immigration visas that cover the same ground as H-1B. So while there's more written about the H-1B program, there are numerous permanent immigrant visas. So like you could even get an H-1B advantage off of permanent immigrant visas by making it easier for folks who are here on H-1B visas to get the permanent immigration status, meaning they would be right. The companies would do better with permanence. There's a lot going on there. So like that same sort of big ground can still be covered under permanent immigration.
Okay. All really good thoughts. So, I mean, it seems like most people kind of agree that we need some sort of large resolution, that there's some desirability there. It's just nailing the wording, and I think we have like lots of different wordings to look at and to refine. It's good. And then we already kind of covered that. Okay, so there's a couple of more kind of like areas to talk about. If people are fine continuing. I don't know if like people think it'd be better to just like kind of plow through and finish things, or if it'd be better to like have another meeting.
I got it pretty soon.
I wouldn't be opposed to another meeting.
Sorry, what?
Oh, sorry, I wouldn't be opposed to another meeting, potentially.
I mean, it's only 6 o'clock on the West Coast, so I'm good.
Okay. So, I mean, I guess we can go ahead and just like plow through as long as there's enough participants, and it's getting recorded. So if folks need to leave, they can watch the end of it. And we'll try to go a little faster. I think we've kind of covered the ones that are a lot more controversial. Okay, so there's potential for a refugee/asylum topic. The idea being that we would essentially just reduce restrictions limited to the asylum or refugee status. The major question I have is, do we like this as a topic area, or do we think that it's better to just like have this folded into a sort of like a larger resolution? So Zach had first comment.
Yeah, so I have so many concerns about the idea of refugee and asylum, not the least of which, and I think probably the most important that we need to recognize, is negative ground. Who is going to try and say that more refugees or people seeking asylum is bad? Who's going to basically say that, oh, they should like get killed in, wherever they're coming from? Like, it seems kind of disingenuous to the community to put them in positions where they have to advocate for a counterplan. Otherwise, they are, bad people. I think that really the only strategy that you can really go for is saying that a foreign government should be the one that is accepting asylum and refugees. And at that point, we then have 173 different actors we have to look into and decide which government is going to be doing it. And then like the burden switches to the AF to have to research like what government is going to be the worst, what government is good, what government's bad, why is this government bad, X, Y, Z. And I think that like refugee asylum for last question for sure is true, that it would be better as a larger resolution, because if you are saying that like you have to say why refugees or asylum seekers have a place to go, I think that becomes very, very tricky to be on the negative and try to say that like this isn't true or like case debate, because like seems like all of the actual cards are going in the direction of saying that yes, we can take in more refugees or more asylum seekers, and like it doesn't seem like there's going to be a very good case debate or an off case debate. So I think that we should be very skeptical of doing anything with refugees or asylum seekers. Even if it's a good idea, it doesn't mean that it should be a debatable resolution. And I think that is also something that we should be keeping in mind as we're looking at these topics.
Jared?
So my question about these particular wordings, and I understand, Zach, your concerns with the topic, is that the primary controversy on refugee asylum, Trump aside, I guess, doesn't seem to be that the question of the number of refugees or asylum seekers, right? You're right. I think it's going to be hard to argue against. The primary controversy is the system by which these folks come in that we have in the United States is completely broken. So like in terms of policy fixes, we would have to look at sort of how hearings are held and how the system is like how these decisions are made. And I don't know that these wordings get at that particular question. You know, I don't know what our deadline is that we're working on here, but I think if we're going to include a refugee asylum seeker resolution, we might want to take a little bit deeper look at sort of like how would we create a wording that allows for discussion of the process rather than focus too much on the number, if that makes any sense. That's just my initial thought on it, because I mean, we could leave it this way, and then the neg ground is the process, right? So, hey, your app says we want to, expand. We're going to take in, instead of 17,000 refugees, we're going to take in 150,000 refugees. The neg gets to say it's not a question of space, it's a question of process, that we don't have enough judges, we don't have enough, like the backlog, and I think we talked about this last week, the backlog on this, and like, children aren't given lawyers, so you've got 3-year-olds at their asylum hearings representing themselves. Stuff like that is where the controversy really starts to take shape. And I don't know, maybe leave that for neg ground, or write the resolution in a way that sort of tackles those questions.
Nadia?
Yeah, so I kind of think I also agree with Zach on the fact that negative ground is not particularly great on this topic. I kind of hear what Jared's saying, though, about like, well, we can attack the process as the negative, but I think my overall problem is and that is something that I've seen as a general trend in the last 2 years now in NFA, at least as somebody coming in relatively from the outside in on this in this community. Judges in NFA seem to have a very, 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 very low bar for what the AF has to prove that it can actually do something, right? A lot of AFs just kind of get spotlighted solvency in a lot of debates that I've watched. And I think it's kind of going to be difficult for us to rely upon a strategy of, oh, well, you can't solve because the system is bad, in a format that traditionally just grants that the AF can probably do some kind of marginal good, and therefore there's a chance that we should vote for it, and thus vote AF. Like I'm not saying that every debate comes down to this, but I've seen a lot of debates that came down to a lot of contested solvency, and judges just vote for the AF anyways because, well, there's 0.01% risk of a solvency advocate, so we vote AF because that means there's a 0.1% chance of things getting better. I think that the burden of proof is too high on the negative in LD to say the AF can't solve, to rely upon like process being a legitimate negative ground, or like legitimate negative ground really, or at least reliable negative ground in this format.
Shanna?
Yeah, so my question is just, and it may be a silly one, I have not dove into the research enough, is there a reason that refugee asylum does not fall under immigration in general? Does anyone know that answer?
It does.
Okay, so this is just an idea of just making it a more limited topic then, right?
Yeah, the idea is like, is there merit to exploring further into a topic that would exclusively be about refugee and or asylum?
Okay, I just wanted to make sure that I wasn't off on some weird planet with the way my brain was working. So cool, thank you.
Riley?
I have the same neg ground concerns about a topic that increases refugees. Just for context, this was a PF topic, and the neg ground ended up being like states have an ethical obligation to follow the social contract, there's a 1% risk of the terrorism disad, was like an argument that was read in finals of Okta's bids. Like, this topic does not have neg ground that is ethical, and it doesn't have neg ground that is fair and balanced. I also think that the process topic, if the topic is like reform the process or whatever, I have a couple of concerns with the wording. The first is I'm not sure how to word it in a way that's like has directionality. Like, it seems to me that any topic that allows the AF to change all of the, like, any of the things that are bad about the process and the status quo would also allow them to go in the other direction. And I think that's like bad for the negative's ability to generate stable links. Yeah, I also had a second concern, but I don't remember it. So cool.
Scott?
Again, Shanna asked this question, and I think it's an important thing we need to just keep in mind throughout the whole thing. Immigration has very particular meanings in the sort of the legal context and in the more popular context. And the immigration topics don't cover asylum seekers and refugees. Right? Immigration, you can see that in the distinctions. There's immigrant visas and non-immigrant visas, and refugees get non-immigrant visas.
Yeah, that's very true. I guess like the DHS would not consider a asylum seeker to be an immigrant, if that's what you're asking.
Yeah, so like we shouldn't go on the assumption that an immigration topic, I think those will be good topicality arguments. So we shouldn't go on the, if we'd like to include issues of refugees and asylum seekers, we need to be careful with the language that we're using with some of the broader topics.
Okay, I see what you're saying. So you're saying if we include the word immigration, would that also, or immigrant, would that also include asylum and a refugee? So no, I don't think so.
It excludes them.
Yeah. I thought you were asking like in a colloquial sense, when we like say immigration, are we also referring to asylum and or refugee status? Oftentimes, yeah.
Yeah, right. And
colloquially, go ahead.
The literature does not have a consistent sort of usage that you'll see people using them interchangeably all over the place, or at least referring to refugees as immigrants. That could become problematic with various wordings.
Mm-hmm. Dustin?
Yeah, I think to solve some of the ground concerns and also to limit it, it might be interesting to specify countries with the asylum. So like two things about that. First is like a limits question. My worry with this sort of rises that if you find a card that's like, we should allow more asylees, we should grant asylum to people from the UK because of Brexit, then you might be able to manufacture some kind of advantage. So it's just kind of going to be a race to the bottom, which is a bit of a concern. But also on top of that, the specifying countries, I think, would provide some net ground, because you could make arguments specific to the economics and political situations in those countries in a way that you might not be able to have predictably with a just general asylees topic.
Mm-hmm. And make some choices about picking ones that are more controversial than others.
Yeah, I mean, Syria might be an interesting case, for instance, because then you get a bunch of international relations disads, potentially.
That makes sense. Yeah, some good thoughts there. So it seems to me like the general consensus is, as currently sort of like constituted, maybe not even an inclusion on the ballot, but maybe if like there's something that sort of gets us closer to something debatable with net ground being a huge concern, maybe inclusion, but probably right now, as things currently are, I know. Another idea. So this one would be a topic that would cover sort of like the enforcement of immigration law. So basically the idea being that we should increase legal protections for immigrants who are subject to enforcement of immigration law by federal agencies. DHS is probably ICE. Various affirmatives would be included that would sort of like provide those enforcement mechanisms. I think you're going to have, similar net ground concerns. Though I definitely know that there are good affirmatives on this topic. And like, depending on what your definition of decent is, decent egg ground. Okay, Ravi.
Okay, so I guess like the first kind of concern I'm having about the topic is that it could, at least in the way that it's kind of worded now, could allow for very kind of small affirmatives that that would affect an area that may not be large or problematic. For example, right? So in theory, you could write like an affirmative that kind of deals with increased, that would like reduce prosecutions for nonviolent drug offenses, right? Or protecting like their access there, or maybe something along the lines of even like missing like probation hearings as another like particular example. I think those are kind of concerning to be negative against.
Mm-hmm. Yeah, I think that's definitely true that there's a need to exclude affirmatives, that like there's not a lot to be negative against. Zach? Zach, do you hear me?
Yeah, I was muted, sorry.
That's okay.
So similarly to the last one, like who is going to be negative against this and say like, yeah, I should be able to do the horrible things. Like Nadia mentioned, like 4 trans women were killed like last week or a while ago, and face no like repercussions for it. Who is going to say like, hey, we shouldn't allow that to happen, or we should allow that to happen? Very difficult to be able to generate any kind of negative positions against it, especially when people just use this as like basically a justification to just say we should get rid of ICE. But also, I think that the way that these resolutions are written becomes very difficult because similar like to what Robbie said, like reforming federal immigration enforcement to substantially increase legal protections for immigrants. What is encompassed under legal protections? Like, is that amendment protections? Is that like, you know, any like, and we could go down a rabbit hole on what like protections are accrued under like the first 10 amendments and how they kind of function together for different individuals and immigrants that are coming to the country. But also like what is included under reform. And I think that like reforming federal immigration enforcement to increase legal protections for immigrants could be like, oh, we're going to reform federal immigration enforcement by saying, oh, you all can't carry guns anymore. Like that in itself would be a reform, and it would increase legal protections for immigrants because they wouldn't get shot at. So like, I think that...
How would that be a legal protection?
Well, I mean, it's like, it would be considered a legal protection under, I think it's, I can't remember what amendment it is, but technically like murdering people, like if police officers murder people, it is considered some sort of a violation under like habeas corpus claims, like they have now taken your body, which creates all kinds of like different problems. And we all know that like it doesn't really abide by that, but you know, yeah, so I think there are definitely like a lot of issues with these that the last one that I don't know if we should really discuss.
Scott?
I looked into this area early on, and perhaps there's some way to salvage it by using the term due process, that the government should adopt policies to better ensure, this is not the right wording, but to better ensure due process for people applying for, or for, you know, to be admitted to the United States, or whatever language you want to use. So it could encompass both refugees and immigrants.
Jared?
So I wanted to just say that while I'm not super comfortable with these particular wordings, and again, no knock against the people doing that work, I think it's really important that we include a resolution on this area. And there's a couple of reasons why. The first reason why is we talked earlier about fidelity to the topic paper. I think a lot of us are forgetting that we squished 2 topic papers together, and that was what was voted on. So the second half of this topic paper was about detention and detention centers.
Mm-hmm.
And none of these other topics get at that question really. So I think that having my secondary reason is that when we had the immigration paper, again, going back to the CETA NDT topic, and it ended up being about visas, a lot of people were very frustrated that that wasn't the topic that they thought they were debating about, because people wanted to talk about how we are dealing with sort of the controversy of illegal immigration in this country. So, you know, while we in our debate community say, how can anybody make these arguments against this? Well, you know, it's a large portion of our neighbors that make these arguments daily. It's our federal government. Like they do make those arguments that you know. So I get that we live in our bubbles, but that's out there, and addressing this controversy. You're right. I don't particularly zealously enjoy the negative ground on this either, but I think that there's probably ways to write a resolution that says we need to address United States policy towards folks who are here with regards to how we enforce our immigration policy. Earlier, I worked on this area a little bit and came up with like kind of areas again. And I know I guess I write a lot of list topics that looked at things like prosecution, detention, and removal in terms of like we should. And the wording was, if I've got it here, like the United States federal government should pass a policy to significantly reduce the prosecution, detention, and or removal of undocumented immigrants in the United States. I think that might be too narrow. I think we could probably expand that. We could make it a little more elegantly written, but I think that those concepts, those topic areas need to be at least on the ballot somewhere. And I also think that it's important, one of the things that was brought up last week, and that one of my debaters is really you know, in favor of, and I think it's at least something we should discuss, is sort of the change of status issue could be addressed under this topic area, the way in which folks who are here can change their status from temporary to permanent, can change their status from illegal to legal, that we can deal with things like DACA, like Dreamers, that sort of whole area of immigration policy that I think we need a resolution on that area of immigration policy. So I'm sympathetic, Zach, but you know, you're judging now, so you don't have to make those debates.
So a couple of things to point out. The first is that immigration enforcement is a term of art that sort of like has a specified list of sort of actions that it includes. So it's not just like a vague term. Like ICE defines what it means when it says immigration enforcement. So there sort of like is an implicit list within the word immigration enforcement. I agree with Jared in that I think a lot of times in debate we kind of like say like, okay, this is undebatable. There's no good args for the neg, and then just like we always have good args for the neg, it's fine. Like an example that I would give is sort of like on the like Latin America topic, I was telling my entire team, hey, this Terra DA is going to be decent. And they were like, what? No, terrible, so racist, so bad. Like, and then we just like won a wreck of debates on like the Terra DA. Because like, I don't know, conservatives like get degrees and write things that are kind of persuasive sometimes too. So, I mean, I don't know. There's like, I don't know. I agree. It's like, it's unsavory. I don't know. I don't necessarily like it. Like the neg side, but like people do write about it. There's reasonable lit that suggests immigration enforcement is good. I don't love those folks, but yeah. Yeah, in terms of the wording, I really like the suggestion about maybe due process being a term that was included. Because I do agree that like legal protections is maybe too vague of a term, but finding some sort of term of art there. Yeah, Justin, Kirk.
So one of the things I think I like about this topic, especially more than the like asylum refugees topic, is I think this kind of splits the difference between the folks who support a courts topic and the folks who are looking at more of a policy side of the debate. It gets at the legal kind of aspect of a topic from a little different angle. Additionally, I completely agree with Jared that like this is something that we keep bringing up in immigration topic papers, but never actually gets decided as a resolution. So it would be somewhat unfair to not include it on a list of topics. I share Zach's concerns with the kind of uncomfortable negative ground, but I always think that there's ways to get out of that. So for example, there was a pick out of sex predators one year that I thought was really effective against the case that increased legal protections. Is like those people don't really deserve more legal protections than they're already getting under the system, etc. So there is some way to have good negative ground without having to kind of compromise ethical or comfortability in debates. So
and another thing to note is that the term legal protections also has tons of definitions. Ravi?
So I actually really like the idea of potentially going the direction of talking about due process, but with the caveat that I'm not sure that we should necessarily use the word due process as a term out in the phrasing, just because it can refer to so many different things. I think that if I were to kind of like narrow down a specific like aspect of due process and like the procedures entailed with that, we could probably talk about like what specific types due process rights should be like afforded to immigrants. In particular, I was doing a lot of reading about kind of like whether or not deportation should be considered like a civil procedure versus a criminal procedure, that type of like evidence standards that kind of go into how the legality of gathering evidence and like being able to engage in deportation in the first place. So I think a debate about it being a civil proceeding versus a criminal proceeding could be a good area within due process to kind of go with it.
Yeah, I guess like, so to me, all those things are just legal protections. And I guess it's honestly a difference in like res writing or like what people prefer. To me, I prefer to just kind of say, here's the umbrella term that's like really vague and broad that includes a ton of things. Avs try to push the limits of that. Negs try to find good limiting definitions, and then we'll just like kind of have it out. But I definitely also like am sympathetic to and see this like the want to sort of like have the resolution sort of like specify for you what affid neg ground is. So yeah, I can kind of see both sides. When I was writing it, I was kind of just thinking like legal protections as an umbrella term. It just kind of means improving the rights of citizens. There's definitions that are very broad. There's definitions that are pretty limited. They'll figure it out. Riley?
Yeah, I think there's a distinction between neg ground and ethical neg ground, and I think it's important to think about that. I think the fact that there are conservatives who have written cards that are persuasive in a vacuum outside of the lived experiences of people, that write links to the terror disad or the econ disad, or that say that waterboarding should be good, or that make any of these claims, does not mean that that should be the core negative ground for a topic that people are debating for a year, right? It doesn't mean that people should be forced to defend those positions. It doesn't mean that immigrants should be forced to defend those positions. And so I think that unless there is neg ground on this topic, that's not just persuasive, but that is ethical, which I think is a higher bar than being persuasive, because Malthus was a persuasive person. He was good at making arguments, but that doesn't mean that his argument is ethical. And so I think that unless there is neg ground, which is ethical, then we should not consider this topic. And I don't know what that neg ground is.
Anyone else? I think that is the end. Yeah. So that kind of constitutes all the resolutions that we have. So that's kind of the end of the presentation, discussion kind of thing. I guess we've either exhausted all the opinions or I've just worn you out. Either way, I think that we'll kind of regroup as a committee and talk about future directions. In terms of like when these things are due, we're thinking more like the 29th. of this month. So yeah, this weekend will probably be like a key time to kind of hone and make some resolutional choices. Maybe one more meeting where we'll kind of like present kind of like a preview of what we're thinking for the ballot, maybe like the day before the deadline.
29th of this month, Chad?
Yeah.
Wow. Okay. That seems soon.
Yeah. A meeting before.
That'd be cool.
Cool.
Have we discussed putting forth a proposal to change the deadline for like when we have to have papers and stuff? Have we done that?
Yeah, I believe the one that Dustin already submitted does some of that.
Okay. I just wanted, I couldn't remember off the top of my head. I want to make sure that we were trying to fix that.
Okay. I'll see you all later.
Thanks, Chad.
Thank you.
Thank you, Chad.
Everybody have a good night.
Hi, everybody.
Adios.